The next case is Oswald Woudhuizen and Power and Design, Inc. and Discovery Property and Casualty Insurance Company versus Mary Smith. I apologize if I butchered the name.
No worries. I apologize. I'm like everybody else dealing with a cold here today, so I apologize for my voice.
How much time would you like for rebuttal?
3 minutes, please.
Excuse me?
3 minutes, please.
3 minutes. All right, let me get the clock set, and then you can go. All right, whenever you're ready.
May it please the court, counsel. This appeal arises from a case where there's really two issues here on appeal. And the first one deals with collateral source offsets, and the second deals with a proposal for settlement. And I'll be first talking about the collateral source issues. And again, the collateral source issue actually has two different parts to that. First, dealing with some medical bills that were adjusted and written off, and the second deals with some Social Security disability benefits. To start off, and there was no real argument about this at the trial court level, but the adjustments that we're looking for to the medical bills are collateral sources. And again, the plaintiff or the appellee did not ever argue at the trial court level that they did not meet the definition of a collateral source. They are portions of bills that were adjusted or written off by agreements between the medical providers, and there is no lien for that. Now, plaintiff did have some medical insurance payments for which a lien exists, but we are not seeking any kind of post-verdict set-off for those amounts. It's only the adjustments. So the collateral source statute, section 768.76, says that the court shall reduce the award by the total amounts that have been paid for the benefit of the claimant or which are otherwise available to the claimant, which are these adjustments. And then in this court, or in this trial court level, we actually the defendants moved before the trial in limine to address the issues of collateral source adjustments. There were some Medicare issues, and we sought to allow the court to say, let's introduce to the evidence the amount that were actually paid and the amounts that are due, but not tell the jury about the adjustments. The court denied that motion, and then also granted a motion in limine of the plaintiff's part to not allow us to talk about collateral sources. So the defendants were put in the position at trial of the jury seeing all of the medical bills and considering all the medical bills and not knowing that some of those portions were adjusted. And they were also told by the jury instructions, they were read the standard instruction from 501.8 that tells them not to reduce their award by anything that they hear that plaintiff might have received from any kind of insurance, disability income, any kind of things like that. So the jury considered the evidence, and they actually awarded her less than her full medical bills. They awarded her $50,000 in past medical expenses, but her medical expenses that were presented to the jury were more than that. When we got to the post-trial motions, the plaintiff argued that we should not be entitled to the set-off because the plaintiff did not get her full medical bills, so they contended that there was no way to know which portions of the bills should be adjusted and which portions that the jury didn't award, so we couldn't get those adjustments. But I think that the case law is clear, and there's a recent case from this court, Rzinski versus McCoy, which dealt with a very similar situation, where the jury did not award the plaintiff the full medical expenses, and then there was an issue of collateral source adjustments. And this Fifth DCA in August of 2017 reversed the trial court order and stated that the trial court should have set off the verdict for that $25,000 plus in collateral source adjustments. So I believe that in this case, in our case, we should be entitled to the full adjustments that have not really been in dispute in this case of over $66,000. And we have never asked the court to go into a negative. From the outset, we thought because she was only awarded $50,000 in past medicals, her adjustments were more than that. We always considered just zeroed out. We did not ask to go into the negative or take away from other portions of her judgment. We believe that the case law is clear when you consider Rosinski versus McCoy, as well as the second DCA case of Carpenter versus Chavez, that the full adjustments should be awarded. The full collateral sources should have been set off from those past medical bills.
Counsel, moving on to the proposal for settlement issue, what's your response to the appellee's position on the proposal for settlement that they could not have accepted it because it would have required them to affirm a falsehood?
Specifically about that, there was two sections of the release that was presented with the proposal, and the first section is titled just kind of a background section. It has titled information, and it listed, the location of the accident, and it did say that the plaintiff was not married. But then there is a second section of the release called the agreements, and those are the portions of the release which are actually the salient terms that she would have had to be agreeing to. And actually, the verification page on the release says that she agrees to the terms of the release, and it does not, in any part of that, make her agree to any part of the background or the introductory sections. I believe that there is a case, Johnson versus Johnson, out of the 3rd DCA that specifically held that prefatory recitations in a contract are not binding or operative provisions of an otherwise unambiguous contract. And I believe that Scrivener's error and the fact that she was married or not married, which is not an issue in the case, her husband did not have a claim in the lawsuit, and it would not have affected the enforceability of the release in any way as far as that introductory statement.
So in essence, the preamble in these kinds of cases, in a proposal for settlement type issue with the release, the preamble, we should just sort of ignore that, or?
Not that it would be ignored. I just do not believe it creates any ambiguity, and I don't think it made her affirm or attest to something that was not true, because the verification portion of the release where she would have had to sign and have notarized specifically says that she would agree to the terms of the agreement. And again, I said that the agreements section was actually the second portion of that release, and it didn't include that one statement that I agree was an error, and we would have no problem striking that word "not" out of the fact that she was married. But I don't think it has any effect on this agreement whatsoever. And again, her husband didn't have a claim, so it wouldn't be something where he was releasing something as far as the release goes.
What about requiring getting a waiver from Medicare?
As far as the Medicare provision of the release is basically just a statement that she will have to satisfy the Medicare lien, just like any of the other liens that she had.
Well, no, I think, didn't it, maybe I'm misremembering, but didn't it actually require the waiver or proof of satisfaction before the settlement payment would be made?
It required the proof of the satisfaction of that lien before the money was dispersed to the plaintiff, from the trust account. We just obviously have had other cases with Medicare where sometimes there's a dispute about the amount that's owed. We like to make sure that we know that Medicare is satisfied with that payment that they receive before the case is dismissed.
I mean, as a practical matter, how often do you really get a release from Medicare? That takes, if you ever get one, it takes a couple of years usually of messing around with it, doesn't it?
It does not. It's not quick, and I don't know about a couple of years. I mean, it's certainly not a quick process.
It's not like you're paying a doctor and the doctor gives you a release saying I've been paid. I mean, with Medicare, it goes into some hole somewhere, and some committee does something with it, and it never comes back, right?
And I would not disagree with the lack of proper organization of Medicare, but Your Honor, that our purpose in that was just to make sure that the Medicare lien was covered, just like all the other liens. Obviously, that subjects.
I mean, I think we understand that. We understand the issue, but I think that from the other perspective, how does a party accept your proposal when they know that in order to do so, they have to get something back from a federal agency?
Well, there's no time limit in my release as far as how long it takes Medicare. I did not say you have to get this Medicare letter to me within 30 days or it's invalid or anything like that. The the amounts, the settlement proceeds would have been paid to the plaintiff, but we just want to make sure that the Medicare lien or conditional payments are satisfied before the case is closed out and the proceeds of whatever's left over from the settlement are dispersed to the plaintiff herself, just to make sure that the Medicare release is covered. It does not require Medicare to approve of the settlement in the proposal or anything of that nature. It's really, it doesn't require affirmative action on Medicare's part. It's really, you pay the lien, they send you a letter. It's not anything that Medicare has to do that we need their approval of. It's just, if the lien is paid, they send a letter. We just want to make sure we get a copy of that letter.
So in other words, they could have accepted the offer, and you would have paid the settlement amount, and it would have just sat in the attorney's trust account until Medicare took action and sent the letter.
Well, until I would presume they would pay Medicare and then they would get a letter back from Medicare, correct?
It says prior to the distribution of any settlement funds, plaintiff will provide to the released parties and their attorneys written documentation from Medicare providing waiver or satisfaction release of the Medicare claims. Again, as a practical matter, having been involved in that, it takes forever if you ever get anything back from them other than acknowledging you sent a letter.
And I think that that's something that, unfortunately, I don't have any control over either, but I do think that it's a release needs to include protections for the released parties. And one of those issues that we've had in the past is Medicare is able to go after a possible tortfeasor to collect fees and things like that if the liens aren't paid.
Regardless of what the requirements were in the release that you wanted them to sign off on, it's they can accept it or they can reject it.
Exactly.
You don't believe that that creates any sort of ambiguity?
I do not. And the other issue of ambiguity that was raised and was really argued at the trial court level was the issue of plaintiff not understanding whether or not their personal claims for their health insurance or their possible uninsured or underinsured motorist coverage claims would be waived. And I disagree. I don't think that there's any ambiguity in our release as far as that goes. I think that the release parties are clearly defined in the release, and the only mention of the word insurer in those release parties is about the insurer for Power Design and Mr. Woudhuizen, not the insurer for any plaintiff. Additionally, the released claims, right under the release party, the release claims are defined, and it's defined as claims that could have been asserted against the released parties. So again, I do not believe that there's any ambiguity in the release regarding any potential waiver of a UM claim, she did not have any pending UM claim at the time. I think that was one of the issues in the cases that was raised by the plaintiff. The plaintiff had a pending UM claim, and there was a confusion about whether that would be waived. But in this case, we do not have that. She did not have any pending UM claim. Additionally, in the two cases, Dryden versus Piedemonte and Vogan Cruz, as well as Nichols, those were all summaries of a release that were attached to a proposal for settlement. The releases themselves were not attached, and I believe that distinguishes our case because our release was attached and there was much more detail than was included in the summaries of the cases that were cited by the plaintiff that were found to be to contain some ambiguities as far as that goes.
Going back to your first point, you were talking about Social Security disability being applied to the lost wage claim, correct?
Correct.
Okay.
The second part of the collateral source argument is that the plaintiff alleged lost wages, and she, kind of similarly to the medical bills issue, the amount that she claimed and lost wages, I think was somewhere over $200,000, but the jury only awarded her $50,000. The plaintiff received Social Security disability benefits of over $90,000 between the time when she started to receive them and the time of the trial. So we would be asking for those set-offs. It is a collateral source. We believe we should be entitled to the set-offs for the benefits that she received from Social Security against the past lost wages that she was awarded. Now, I concede that the plaintiff was not approved for and did not start to get Social Security disability benefits until April of 2011, which is about a little over a year after the accident. But she also testified that she continued to work on and off after the accident through October of 2010. One of plaintiff's arguments at the trial court level was that because $50,000 is about the same amount that she was making a year, that we should assume that the jury gave her 1 year in past lost wages, and she didn't start getting the Social Security until after that year, so we shouldn't get any benefit, we shouldn't get any set-off. But I don't think that we should be able to assume that. I don't think that there is any evidence to suggest that the jury was looking at the 1 year mark, especially considering the evidence that was presented, that she did continue to work on and off through October. So I do not believe that we should just assume that the $50,000 mark was from January of 2010 to January of 2011 when she was not yet receiving those benefits. I believe that the overlap of about 3.5 years between when she started receiving the Social Security benefits and the trial, the jury awarded $50,000 for that time period. For 3.5 years of that time period, she was receiving those Social Security disability benefits, and I believe that she should be entitled to the set-off as dictated by the statute that says that we shall be set off in the verdict. Any other questions? I'll reserve the rest of my time for my rebuttal.
May it please the court, counsel. I'm Edward Rue, and I represent Mary Smith, the appellee. I'd like to start out by addressing one thing that was raised initially by counsel, and that was the set-off for medical bills. While that issue was addressed down at the trial court level, it wasn't briefed at all in this case. And in our answer brief, we specifically raised that issue and indicated that it had been waived under Collins versus Asset Group LLC versus Lee, which is a decision from this court.
It's not addressed in the reply brief either, is it?
No, it's not addressed at all. So I didn't know that was an issue for today. So the legal arguments are very similar for the medical set-offs or the Social Security, but I believe that issue has been waived. Moving on to the Social Security disability payments, the issue here is the burden of proof. Appellants had the burden of proof at the trial court level of proving their entitlement to settlement, which was an affirmative defense they raised in their answer. The cases are clear. We cite them in our brief that the burden is on the party who is asking for the set-off to prove their entitlement to that set-off. And what happened here is that Ms. Smith, the accident happens in January 26th of 2010. She misses some work initially. She gets PIP benefits, which we did not contest. We agreed that they got this offset for the PIP lost wage claims that were paid. She also had short-term and long-term disability policies that were private policies that both down below and at this level, appellants have conceded there was a right of subrogation for those payments. And so she received those payments during that first year as well. So the issue is they're asking for a set-off for Social Security disability payments that started 14 months and 20 days or so. So I'll round up and say 15 months. 15 months after the accident took place. Because what happens is she works off and on periodically. She gets the short-term and long-term disability. She gets PIP benefits. And she's technically still employed while she's receiving short-term and long-term disability. Then she formally leaves employment on October 15th of 2010. And under Social Security's rules and regulations, and I cite the specific federal regulation in the brief, it's 20 CFR. I forget the rest of it at the moment. But Social Security doesn't start to make their payments until 5 months after they establish your date of onset. So there's a 5-month period when you don't get any benefits. So her date of onset is established by Social Security as the date she last worked, which is October 15th of 2010. And then 5 months after that, she receives her first payment in May. And the payment in May of 2011, it contains a payment for April as well. So
how can we be confident that the $50,000 is for that period? And I know where you're heading because we've read the briefs, but how can we be confident that that's how the jury came up with that number?
Well,
I agree with you. It may be totally consistent. I don't disagree with you, and I don't think counsel disagrees with you that it could be consistent with that. But you proved up a claim for lost wages. They proved up that she got collateral sources that are for lost wages, in essence. Why aren't they entitled to the set-off under the statute?
Because what they failed to prove, both at the trial court level and here, is that there's a duplication of benefits. What we're looking for is not just, was there a loss of wages, and did the jury award lost wages? It's, did the lost wages that were awarded by the jury, did they duplicate the benefits that she
Counsel,
received?
wouldn't that require the jury in their verdict to sort of make an award for every single month over a 5-year span?
Well, they could have, and appellants.
But would that be proper?
Yes, I think they could have asked for an itemized verdict as far as the lost wages goes. They did not do that. They just had a general verdict on that issue.
Have you seen a verdict form where somebody went month by month on lost wages? I'm not saying it hasn't happened, but I never saw one.
Well, I mean, they could have gone year by year.
Yes or no? Have you ever seen one?
I have not seen one on lost wages. I've seen that done on medical bills. You know, this medical clinic, that medical clinic, and they ask
Especially
for.
where there's an intervening accident or an
Right,
illness or something.
right. So I've seen many things itemized in my recollection. Have I specifically seen it done with lost wages? No, but the issue here is that it's more complicated than your typical case. In your typical case, someone has an accident, they go out of work, they're out of work for a period of time, and then they get disability benefits, perhaps. It's easy to see a set-off in those cases. But here, how is the trial court to determine that that $50,000 that was given by the jury wasn't for the same period of time for which there was a right of subrogation on those long-term and short-term disability policies, that they don't get a set-off for? How are we to determine that that $50,000 isn't the same as the PIP benefits that they already got a set-off for? Because they don't get to double dip as well. So they don't get a set-off for the stuff where there's a right of subrogation. We know that took place during the first year. We don't know exactly when the jury was thinking about in terms of when they awarded the lost damages, but the burden to prove that, either with some evidence or argument, was on appellants.
Is there a provision in the statute that says specifically you only get a set-off for lost wages if you prove that this wage and this collateral source is a duplication?
The statute does specifically say, if 768.761 does say that it's for damages that are awarded to compensate the claimant for losses sustained. And the way that statute has been interpreted by the courts, including this court in Dolgan versus Dombrowski, is that there's the person who's claiming the set-off has the burden of proving that there's a duplication of benefits, that there's no double recovery. So for instance, if someone received Social Security benefits for something that was unrelated to the accident, there would be no set-off. And the same goes for...
But these benefits were related to the accident.
Well, they may have been. Their argument down at the trial court was that she was not disabled, and they offered testimony. The record is not very well developed in terms of that, but you can see in the record there's the testimony of our economist, Stephen Collard, who testified about what her earnings were and that she earned about $50,000 a year, and he gave an analysis on why vocationally she would be disabled. And then they had another expert, Dr. Selmans, who's mentioned in the motion practice in terms of there was a motion for additor for new trial, and that evidence was referenced, but the testimony from Dr. Selmans is not in the record. But the jury was, the argument was that she wasn't disabled. There was no permanent disability, and they found there was no permanent injury, so that's consistent with their finding. We asked for about $250,000 in lost wages. The jury awarded $50,000, which would tend to indicate to me that they awarded a closed period of wage loss, not ongoing wage loss into the future. So why they should get set-offs for these payments that were made 15 months after the accident going forward is unclear, and the burden, again, was on them.
Well, going back to Judge Edwards' question, where can you point us? I mean, you kind of pointed us to a case, and I'm sure we'll go back and look at it. I know I will, but where can you point us in the statute? Where does it say that that their burden of proof includes demonstrating that every dollar is not, that no dollar is duplicated between the two?
The statute says that. If you look, I think it's subsection 4, when you're talking about the collateral sources with the right of subrogation, it does mention that it's only for the benefits that were paid.
But that's a different issue, right? Well, that's where there's a right of subrogation. That's not
Right.
an issue here.
Right. Well, think of it this way. I mean, if the policy, the courts all generally agree that the policy behind this set-off statute, and the courts have been consistent, this court and pretty much every other court in the state of Florida, about these set-off statutes, the purpose is to avoid a duplication of benefits. Sometimes the term is phrased a double recovery or a windfall, but the idea is the same. Are you getting benefits from the jury that were also compensated by a collateral source.
Well, the legislature's purpose and the way they actually draft up the statute, sometimes, there's a little bit of a difference there. And when you read the statute, I just don't see where the actual language of the statute requires that the party asking for the set-off prove that every dollar has not been duplicated by the jury.
Well,
And I'm going to pile on before you even answer.
Go ahead.
Because looking at the statute, it says, the court shall reduce the amount of such award, meaning the losses, by the total of all amounts which have been paid for the benefit of the claimant. The only exception is where there's the subrogation right.
Okay.
So, I mean, it's...
I agree that the statute says what it says, and I'm not going to argue that the statute says anything else. But the statute is not a new statute, and it's been subject to interpretation over the years by...
Well, you certainly wouldn't claim that the statute's ambiguous in any way. It seems pretty clear.
I think if you interpret the statute to say that any collateral source payment that is made between an injury and a verdict is automatically set off, regardless of whether or not the jury awarded that collateral source, I think that's an absurd result, and the statute should not be interpreted that way. Because not only is that not further the policy objective behind the statute, but it actually would lead to an unearned and unjust windfall to tortfeasors.
But in this case, they were both relating to lost wages, correct?
But the jury didn't award all the lost wages. Like, for instance, they're asking for a set-off of $96,000, or the total amount, $50,000. Those payments, I mean, how is the trial court to determine, given the evidence in the record, that that's not for the payments that we have a right of subrogation for? We know they don't get a set-off for the payments that we have a right of subrogation for. They didn't even tell the trial court how much those payments were.
You could have let it all come in. You moved in limine to keep all this information out. The jury could have heard it all and made their decision fully informed.
Right, but there's obviously reasons.
But you chose not to, so if anybody's frustrating the proof in the jury's decision, perhaps it's the plaintiff.
Well, generally, there is a collateral source rule that, I mean, it's been modified by the statute, but the evidentiary portion of it still stands, and for good reason. The jury is not supposed to know about all these collateral source payments because they can influence their decision. And generally, the trial court does these collateral source set-offs specifically for things like Social Security disability or for medical insurance that the jury is not supposed to hear about. They do that after the fact, but the person claiming the set-off still has the burden of proof. So, I mean, we could have, but that would not have been a reasonable strategy. I mean, there's a reason for the collateral source rule, and that's why we didn't want the jury hearing about health insurance and Medicare and all that stuff. There are good policy reasons for them not to do that. So, yes, I mean, with regard to the statute, but the language of the statute is what the language is, but as it's been interpreted, it is to avoid a duplication of benefits.
Can you give us another case? I just reread the Dolgan case, and I'm not sure that it says what you said it says.
There's King v. Birch that was cited in our brief, that I believe is a first DCA case. Hurtado versus D'Souza, 166 SO 3rd 831. The purpose of section 768.76 is to prevent a double recovery by the claimant.
Are there any cases other than sort of the general, especially out of the Fifth or the Supreme Court, are there any cases that, other than a general statement of the purpose, which again, the purpose is one thing, and how the legislature tackles that purpose might be a different thing altogether. Is there any binding case law that says we look at whether a dollar of a claim set-off has been duplicated by the jury?
Yes, just a second, Your Honor. There actually is. It was cited down below.
Wasn't good enough for us, though?
Well, my opinion at the time, not being subject to questioning, was that it wasn't as germane as some other cases, so I chose not to rely upon it. It is, I believe it's the Morales case.
Is it a Fifth?
I do not believe it is a Fifth DCA case, but it does specifically deal with the set-off for Social Security benefits that were not paid. It's Morales versus Scherer, 528 SO 2nd 1. It's the fourth DCA, 1988. In that case, it's not really well developed there, but the court said there that she was receiving the Social Security disability benefits for something that wasn't awarded by the jury, and so that there was no set-off. And I think the same thing, I mean, let's think about this in terms of a medical claim. Let's say you have, and we were talking about itemized verdicts, Judge Edwards. A lot of times we will itemize verdicts by medical expenses and say maybe a surgery, whether or not that surgery is related, is a big issue. So let's say the jury has an itemized verdict and they say surgery to shoulder, not related. I think everyone would agree that at that point they don't get a set-off for the collateral sources that were paid for the shoulder surgery, because the jury didn't award those. The purpose is to avoid a duplication of benefits. And again, the burden is on them. So everyone at the trial court level conceded that there were short-term and long-term disability payments for which there were a right of subrogation that were made during that first year. And we conceded that they had PIP payments that were made during that first year. They don't get to double dip any more than we do. They don't get double set-offs for PIP and Social Security disability for the same payments. So they have the burden of demonstrating in a situation like this that those benefits were awarded by the jury. And the statute does talk about in subsection 1 that it only applies when damages are awarded to compensate the claimant for losses sustained. So if it's just that there's an incident and then afterwards there are collateral source payments, and that's all they have to show, they don't have to show a duplication of benefits, that would truly lead to an unjust windfall for tortfeasors. And that was not the intention of this statute, nor has it ever been interpreted that way.
When you look at the statute, were damages award for this loss? Yes, she was injured in the accident, she received benefits, an award from the jury for lost wages. Then you go on, it says the court shall reduce the amount of such award by the total of all amounts which are paid for on behalf of the claimant. It couldn't be any, I agree with you. It may not make sense, it may not serve the goal, but in terms of reading the statute.
Well, I agree with you. There's also no case that says, I'm not aware of any, and I looked, that says that you get a set-off for something that was not awarded by the jury. I couldn't find a single case where the court awarded a set-off.
We don't know, right? I mean, we don't know which lost wages in this case.
Well,
Isn't that your argument, that we just don't know?
And that was, well, we don't know because it was never shown. I mean, there was no, for instance, they could have come at and said, well, here's the log for the short-term disability and long-term disability payments. They were paid during this period. Here's the log for PIP. It was paid during this period. And here's why we think the jury would have awarded it starting 15 months after the accident, that those benefits were duplicated by what the jury awarded. We know that they had testimony from our economists that she earned approximately $50,000 a year. The jury award just happens to be $50,000. Does that mean that is what it was for? It doesn't necessarily mean. But to the extent that assumptions are being made, they have a burden of proving by a preponderance of the evidence there was a duplication of benefits. And they haven't done that. They didn't develop that at the trial court, and they haven't developed that in the record here. There isn't even a transcript from Ms. Smith in the record about her lost wages or what she testified to. They were relying in their reply brief upon questions that were asked by the jury that shows she was off for periods of time.
Maybe if you don't mind, let's turn to the proposal for settlement.
Sure.
I understand the concern about whether Ms. Smith was married or not married, but in terms of what benefits were potentially being released or what claims were potentially being released, I don't understand how that's ambiguous. It's releasing, and hang on just a second, as I read it, it was releasing essentially the defendant and its insurer from claims associated with this wreck. The defendant individually or the company isn't providing health insurance to your client or UM or UIM. So that part I don't understand the ambiguity there.
I'll try to explain that to you. There's this 11-page release on this relatively normal tort claim has several sections. One of them is the parties released, and then there's claims released, and that claims released has paragraph 2 and paragraph 2A. There are two different sections there. And the sections and the language is very, very broad in the claims released. There's nothing in the parties released language that limits the claims released to just the parties that are being released. And the claims release language is exceedingly broad, and it doesn't limit itself to just the claims that were made or could have been made against the parties at the trial court level. It says any and all claims arising out of the incident, or claims that could have been made against the parties, or claims that were made against the parties. So there's two disjunctives in there, and that stands to broaden those claims released language well beyond just the claims against the parties. And all that was set forth. There's something I would like to point out that if you look at sections G and H of the release, and I'll just refer to it as one release because even though there were two, they were identical besides for the amount. Sections G and H had language in it. If you look at the fourth paragraph down in section G, I believe it is, it says, and for the record site, it's 1831 or 1845, all future medical services are the sole responsibility of plaintiff and have been factored into the settlement amount and are to be paid out of the settlement funds. That is exactly the situation that this court confronted in Connecticut Insurance versus Dias. And that's why we have this language that's typically in releases, like, for instance, Judge Berger, you wrote the Mathis versus, I'm forgetting the second party at this point, but the Mathis case.
As well, but
and in 2014,
name.
and in that case, you had a proposal for settlement with a release attached, and it contained what we colloquially refer to as Dias language, preserving all those first-party claims. And that was one of the things quoted by the court because it removed ambiguity. The same is true in Wallen versus Tyson, which was another 50CA case that was cited in the briefs, also had that language. This doesn't have that language. The express terms of this release eliminate all first-party health insurance claims. They say that you're being fully compensated for all your first-party claims, and that all those will be paid out of these settlement funds.
In paragraph 2, the very first part, not the introductory thing, it applies to claims in any way arising from the incident or the subject of the claim that has been asserted or could have been asserted against any of the released parties. That's why I'm asking you again, how could you assert a claim for health insurance or UM or UIM against any of the released parties?
Well, because that paragraph conflicts with paragraph 2. So there's that prefatory paragraph, and then you have paragraph 2, which has that disjunctive language about any claims, and it specifically includes medical claims, psychological expenses, statutory claims such as in Vogan versus Cruz, that was an issue. None of those were made here. It includes those claims and says all those claims arising out of the incident, or the ones that were made against the party, or that could have been made against the parties down below. So it's much more expansive.
Couldn't that provision be read the other way, though, as well?
Well, that's true, and that's why it's ambiguous.
And if you read both paragraphs in the same document,
right,
couldn't you harmonize the two?
I don't think you can harmonize those two and say the medical benefits are not being waived when you look at the Medicare and the paragraphs G and H and what they provide.
You're out of time.
I know.
Thank you.
Thank you, Your Honors.
Thank you. And actually, to pick up where you were just talking about the release language as for a proposal for settlement, in paragraph 2 about the release claims that was being read to you, it says, any all claims known or should know arising from the incident or that are subject to the claim or that has been asserted, which means, I guess, whatever they asserted, whether it's related to the incident or not, whatever they asserted in the claim or could have asserted in that claim against any of the released parties. So I don't believe that there's any difference between the release claims in paragraph 2 and the release claims further up in the release that it was attached to the proposal for settlement. So I don't believe there's any ambiguity as far as the claims that were being released are against the released parties that were defined by paragraph 1 of the release. Again,
Do you agree that on appeal, you guys didn't discuss the medical bills? I was looking for it. I couldn't find it. Counsel couldn't find it. I don't see where it's addressed.
I disagree. I do agree that
Where?
we didn't talk about the payments. And I know that in the answer brief, he said that we did not raise any issue of medical payments being a collateral source. And we aren't raising issue of the collateral payments, the collateral source payments, because we do believe that there is a lien right, and we have never argued that issue. So we do agree that the payments that were made by the medical insurers are not at issue in this case, and we are not raising that issue. That, I agree, is waived. That was not. One of the other issues that was brought up on counsel's argument was about his contention that it was our burden to prove the duplication. And one of the cases that was cited in the answer brief in support of that was a Pate v. Renfro, which is a first DCA case. But I don't think that that's really what the Pate case says. It was really about future PIP benefits and whether future PIP benefits could be set off. I don't think that's the case here. We are not alleging that we should get a set off for any future payments that she had from the Social Security disability, and she was not awarded any future medical or future wages. It's only about the wages that she was awarded. And I do think that it's also important that the 1 year, she did testify that she worked on and off through October. So that 1 year, by just arbitrarily picking, January 2010 to start that 1 year where we should just assume they awarded 1 year of damages, I don't believe that's supported by the evidence. Additionally, as far as the duplication, you mentioned the itemized verdict for, each week or each month that she was out of work, and that would certainly be cumbersome and I believe unreasonable in most cases. And I think that the same thought needs to be taken as regard to what would have been required of us as the defendants to request for a verdict form as regarding the medical bills. Because in this case, I don't even believe we could have just listed each clinic. It's almost like the jury would have had to find whether each date of service was related, because adjustments are typically, made on a date of service basis, and some payments are made and some adjustments are made. And I think that would really be burdensome to the jury and make us reach an unreasonable I think it would certainly take a whole lot longer time, and I don't think it was reasonable in this case. I think the only way that the defendants would have been able to show any duplication is by telling the jury that there were adjustments that they could consider, and that was something that we were not allowed to do at the trial court level. So I don't believe we had any opportunity to show the jury that they should have done anything other than just award the bills that they thought were reasonable without itemizing it. Anything else?
Nope.
No, thank you.
Thank you very much.
All right, we will take a brief